for treatment at Sunshine had their accident in your region.
That's correct.
Okay, so I'm hoping that clears it, Honorable Matun. Thank you.
No, perfect, Chair. That's what I was trying to establish, because I'm trying to establish how do you end up being. Okay, no, I think it further clears some mist in my head. Now, given that so you are saying that after the service level agreement was discontinued, they continued having patients that, for instance, that were from the province where you were heading.
Can you make clarity on that question?
I'm saying after 2018, when the service level agreement between RAF and them was discontinued, did they continue receiving patients that were from your province?
Okay. The issue of cooperation agreement, not service level agreement. It's an arrangement for the fund to try and get whichever assistance based on whatever motivation that happened at the time. But this does not drive whether a victim can be admitted or not claim, or it's not an issue. Let me put it in an example. It's not like a tender issue where a person needs to apply and get an approval so they can render services to you as a supplier. No, this is an issue that is governed within the Act Section 17, and all hospitals or medical practitioners can treat the victim regardless whether there is a document or not. So for me, I will say it was business as usual, just like all others. But the issue of the termination of mandate in 2018 or it was never communicated actually to the fund. I only get to know about this MOU in my case when I'm actually charged to say there was an MOU. When at the time there is an email where it was commented. I did send an email to seek clarity. What is this about? Because it actually confused me. I never knew about the MOU. I never knew about the agreement or anything. Suddenly, someone in Joburg is inquiring about office space to occupy in 2018. And then in 2019, a stakeholder manager adds us in mainland to say, there is this issue. Please be aware there is a mandate terminated. And then we sent an email to get clarity. What's this about? And I was told it's got nothing to do with mainland. This email is got something to do with Joburg. So basically, this issue of termination of mandate, it was never communicated by the organization. From the time I came in 2014, not a single time there was an issue of MOU with Sunshine communicated, because my opinion or my assumption, it's because the issues of claims and the MOU were two separate issues. Okay.
No, thanks. I think it would further. Yeah. I want to check. When you came in 2014, you came in to directly be you were in originations, the manager there.
That's correct. I was appointed from external. I was not an employee in RAF.
Oh, so I think it says origination, customer care of some sort. Am I correct?
That's correct.
So I would assume that you nonetheless held a law degree or some sort of a relevant degree, right?
Not at all. The environment I was in did not require a legal degree, because we were not dealing with legal issues. But you needed training on. Internally in RAF, they've got an MVA training when you start working in RAF. So you'll go through that training to understand the issues of liability of the fund and its mandate and everything. Basically, that's what you need. So they give you more information to equip you to assist the direct claimants. You don't need a law degree to literally assist, but you need an understanding on the mandate as well as the benefits that the client can access and how to deal with these forms. On my side, of course, it was an additional leadership background and experience. That's all I needed.
So when they moved you, I think they moved you to acting manager litigations, right?
Acting senior manager.
The intention was for you to change that department to a law, I think, what is the word? Kind of a law department, right? What is it? I saw it somewhere. Or it was to change the department from being a litigation to a legal department.
So when I was approached, it was to assist with the implementation of the new business model. So in the new business model, I think I've shared the document with the team. In the new business model, the litigation department then becomes legal administration. So it's like new structures within the organization through this transformation process. So the issue was not about illegal, but it was about the function of transformation and change into the new business model, how you support change and assist with transformation. So within that, there is a lot of aspects. For instance, it's going to be the issues of how do people manage with change, how do you monitor the gaps and what's on the past structure, how it moves. I'm just clearly just putting on what you're expecting during the transition. So my role had nothing to do with legal or litigation when I was approached, but in terms of how I'm going to help with this change and transformation as they go through to the new structure within legal administration team.
So I would assume that you had a belief that even though without a legal qualification, that you possessed enough experience and a strong background to head this transformation from litigation to legal department.
Yes, as a manager, you do possess the quality and expertise to deal with change management and transformation, because in there you are not looking at an expertise of being legal, but managerial expertise in how you manage change, because this you do day to day within your own environment.
Okay, no, thank you. I'm also not good. Just a few questions as well too. One, I want to check, when the law firms refused to return files, what steps did you take as a fund?
Yeah, Chair. So during that time, what we did was that we called law firms on those matters to settle them. So we did extensive block settlements on those matters. We also, if I recall correctly, we also got a firm of, or rather, we got a panel from the GEPF, I think it was, to assist with some of those matters while we were in the space of negotiating with the Solicitor-General in order to get state attorneys to deal with RAF matters.
So if I get you correctly, you are saying to us the panel of attorneys that you had before were giving you problems in returning the files of the cases that they were already dealing with when you terminate, when their contract ended, because I think we must use the right word, when their contract ended. I'm asking you, when you were finding this difficulty of them returning the files to you, what did you do about it between you and them?
Chair, also I think it's necessary that I state that during that time I was in panel management. So in terms of litigation, I wasn't leading litigation, so I wasn't in that space. But I do know of the steps that were taken as I advised you now. But personally, no, there was nothing I could do in that time.
So, according to your knowledge, there was nothing that was, there was no steps that were taken against the attorneys. They just took, they kind of came up with other controls to compensate that they can't get file in order for them to deal with the cases.
Honorable Maduna, I don't want to speak out of turn, but I do know that there was quite extensive litigation against the firms to get them to bring back the files or to hand over back the files. I'm sure you can find it, it's in the public space, but personally I can't speak to that.
Thanks, Chair. I think, Chair, it's important that we must get the list of these law firms. If we don't already have it in place, I believe they should be published. These are people who are part of the problem. Thank you. Mr. Phillips, I believe you said that in order for you to be able to adequately deal with the requirements, litigation and so on of RAF, you need about 204 attorneys, right? The estimate that you are making, it's just the estimate.
Thanks for the question, Honourable Maduna. I indicated we needed an approximate number of 204 additional to the numbers that we already have on the approved structure.
So in the approved structure, we have 310?
The total complement for the full grouping, which includes state attorneys as well as the support staff, is 353.
The current appointed is 110?
Honourable Maduna, at the moment we have 137 with provisioning for 149.
Just straightforward, Mr. Phillips. What's the issue? Why you are not filling all of them?
As I indicated, recruitment can be quite a complex process for the state attorney task grades, task grade 15 and task grade 16. And as I indicated in my presentation, it takes between 9 and 12 months for us from end to end, from the date of advertisement to the date of the commencement on that level. It's a little bit easier with the legal secretaries and paralegals, and we are running recruitment basically all the time. The whole year through, we are running recruitment.
Perhaps shortly, can you just summarily, can you give us what is this that is complex in these appointments? So
the process, because we are advertising internally, Honourable Maduna, in my evidence earlier, I indicated that the compromise was that I would advertise internally in the organisation first, and if we were unable to get suitable candidates, we would then move to external processes. The response to the advertisements that we place across the organisation for all of our positions is phenomenal. And there is a summative test that is written initially in the first component of the interview is a summative test. And then obviously whoever is successful in that test above a certain pass mark then goes through to the interview phase. When we are placing for state attorneys, obviously in the interview phase, we also include the head of office in the region where the successful candidate is going to be placed. And at the end of that interview series, the successful candidate then has to go for a battery of psychometric tests, which is required in terms of our resourcing policy. So that level of complexity when it comes to placement is obviously for those task 15 and task 16 levels. In terms of the legal secretaries and paralegals, similarly, there is a summative test. With the interview phase, however, the interview phase consists of an interview and then a drafting assignment. So for the legal secretaries, we require the legal secretaries who are successful in the interview phase to draft a document, and the same for the paralegal. They're given a set of facts and then they have to draft generally, we had an interview today. There was a request for a special plea from the candidates. So it's a little bit quicker in terms of the turnaround time.
So, Honourable Maduna, you are in the referees at a time now, but I'll allow you one more.
No, Chair, actually, I mean, it's like I've timed myself because that was actually the second to last question that I have. Yeah. I think my last question would be, Mr. Phillips, given that you have arrived in 2023 now. Now, and approximately, it's good that you know what you need as a department. Ne? But now, I want to check, in terms of the board-approved strategic plan, when you do your needs analysis, is this incorporated into it? I'm asking this because we need to know whether we're going to, these undefended cases are going to continue, or this is a matter that will unrest at some point. I think that was my last question. And as a comment, Chair, I must say that it's very disturbing. I know that there is a judgment now that says it's wrong. You know, I think I've spoken about this before, and it's just how South Africa is. And I think this is part of our problems that we should be decisive in dealing with, especially when it comes to the issue of transformation of the blueprint of South African government as a whole. That is why you find it acceptable that when a child from a black family claims will get will be awarded something smaller than what a child from a white family will get. This is why even if I go to a bank, I go to borrow money, I always pay higher interest rate. I have multiple degrees, but I know the interest rate I pay is more than a white person that has matric. It's a quite unfortunate situation, a situation of South Africa, and I'm just saying it as a commentator that it's worrisome, and I think we need to, all of us, play our role. I thank you, Mr. Phillips. That was my last question, not the comment. That was my last question. The comment is not yours. Thank you.
Thank you very much, Honorable Matuna, and noted. Can I just ask a follow-up on your behalf, which I was hoping you would ask? Mr. Phillips, so what's your budget right now?
We revert to you on that point in writing to give you the specifics of the budget.
You don't have a ballpark figure?
Chair, I would have to go back to the budgetary. I do have a budget at the moment, but in a ballpark, it's split into several professional services. I will revert in writing if that's in order, Chair.
Okay, so have you been part of any cost comparison analysis? Because, you know, what I like about what you said is that the number of lawyers that you need has landed up in the same estimate of the warm bodies that were sitting with the law firms. It would be interesting to see what the salaries and operational cost, or, you know, support staff and all of that costs, the drivers which you used to pay lawyers, right? All of that. So it would be interesting to see on a like-for-like basis what the cost was before and what the cost is now, because what we're interested in is on an empirical basis for us to see what's what's more cost effective. But we do want your area and Mr. Baloyi to be adequately resourced so that you can do this work. So if you can organize that at a later stage, we get an educated estimate, if you know what I mean. We're not gonna kill you about decimals.
Noted, Chair, and we will certainly attend to that.
All right, thank you very much. Honorable Skosan, over to you.
No, thank you very much, Chairperson, and good evening to everyone. No, we appreciate the opportunity to engage with our witnesses. One, Mr. Phillips, I think you did indicate that you once worked for RAF, I think from 97 till 2004, and then you left, but I didn't capture as to when did you come back?
Thank you for the question, Honourable Member. I came back in the 1st of November 2021.
Okay, 1st November 2021. All right. So, are you one of the lucky managers who survived the bloodbath?
The bloodbath had occurred by the time I arrived in the Johannesburg region. So it had already occurred.
Okay. All right. Yeah, so I think I've heard you, I think when you were, explaining challenges regarding the panel of attorneys and the fact that the costs were escalating and all that, the fact that the reason that it was terminated, it was to deal with the escalating cost and all that. So, but with hindsight, when you look back, taking into account challenges that RAF is facing and the escalating costs that are facing RAF currently, would you say it was a good decision to terminate the panel of attorneys?
Thank you for that question. If you look at the annual report that details the costs over a period of time, the road accident funds costs in the last annual report were the second lowest that they've been since 2015, if I'm remembering correctly. And that's certainly an indication as to the fact that we are able to make progress in terms of reduction of legal costs when it comes to the presentation of claims to court. I think it was a good decision, and I still strongly believe that with proper capacitation, the state attorney model can do absolute wonders.
Okay. So your challenge now is the issue of the internal capacity.
That's correct.
And what are the plans to remedy that?
As I indicated, Honourable Member, I'm constantly engaged in. We've actually just had advertisements going out for 14 High Court state attorneys that went out on Friday, as well as numerous paralegal and legal secretary positions. So we are advertising en masse, and we have recruitment constantly every week. We're in interviews, we are in summative tests, and we are ensuring that that capacity is moving quickly in terms of fully capacitating the structure.
Okay. No, thank you very much. Coming to you, Mr. Baloyi, I think you did indicate that you were not only managing the panel of attorneys, but you were also managing panel of medical experts. And there's Mrs. Cecilia Mini, who gave evidence to this committee that even during the era when there was still a panel of medical experts, but RAF would sometimes utilize the service of medical experts who were not on that particular panel. Why was that the case?
Thank you, Honourable Skosana. So you would find that, I think, when it comes to certain specialities, there are few and far between. For example, I think radiologists and neurosurgeons. I think I know there are around 300 neurosurgeons in South Africa. So in terms of just making sure you have the capacity that you require to deal with specific matters, you would find that the former panel who would engage these experts, and then we would ultimately pay them. But I mean, I need to qualify that by saying that there needs to be pre-authorization first before this can happen. So you were finding that the panel members would sometimes appoint these experts without the proper authorization, which obviously led to some issues around payments because they were not meant to be doing that work. There was no authorization in terms of what's in the SLA.
Okay. So what is the main reason the panel of medical experts was terminated?
I honestly can't speak to that, honourable member. That's not within my tenure, unfortunately.
So you don't know? You were not even told?
No, because I mean, I think the contract came to an end when I was already out of the department. So I really can't say, quite honestly.
Also, currently you are in a different department?
Yes, I'm currently in legal.
Okay, so you don't even know about issues of payments because we are told that there are quite a number of experts who have up to today have not been paid. Some dates back to I think more than 5 years ago, who have not been paid yet. Some of them, their reports were used by RAF, but then up to today they haven't been paid, which dates back to more than 5 years ago.
I only know of the fact that in terms of experts that weren't paid, it was the ones, as I said, that didn't have the pre-authorization to do particular pieces of work for the RAF. They were appointed by the panel, but there was no authorization. So obviously then, for auditing purposes, that couldn't be paid for various reasons, as I said, in terms of the SLA.
Okay, yeah, but then I think I get that point. But there's an argument that even their reports were used, as much as they didn't have the authorization, but RAF used their reports. What is your comment on that?
That's true, Chair, member, so I can't comment on that. Yes, some of those reports were indeed used, but unfortunately the policy is thus that if the appointment is not in terms of that pre-authorization, it simply can't be paid, and that was the organizational stance.
Okay. Coming to you, Ms. Mtetwa, I have got a cousin whose name is Christina, but my late grandmother used to call her Christina.
Can call him Zala.
So, during the implementation of the direct claims strategy from 2014, how did you handle the issue of REF 1 form? Or is it a different form now? Because I think there's one witness here who told us that that REF 1 form is very complicated to an extent that even educated people, they find it very difficult to complete it. Hence, many people would opt to go for attorneys to help them. So during that time when you were implementing these direct claim strategies, how were you handling that particular form? Or it has since changed from what it used to be?
Yes, the form has changed. It's actually, I think what's most important, what now, it's the inclusion in the new form versus the old form. So with the old form, yes, it was a bit simpler than the complicated, I think, which is driven by the requirements for compliance. I think that's basically where the changes now come in. But in terms of other information, one can complete that form. That will be your personal details where the accident occurred and. But there is now the portion where there's now compliance documents that are required, which then just makes this lodgement process complicated more than it could have been in the past. So the form itself, yes, one can complete it. If you can read English, you will complete the form. If you can't, through an assistant of any child in the house that can read English, you can complete the form. So the issue basically, it's not on the putting a pen on the form. It's basically understanding how this whole process works. I'm not sure if that covers it.
So the earlier one, it was simple to fill. Is that what you are saying?
That's correct.
So why was it changed?
I don't know. I don't know, because I really cannot comment on why it was changed, but I can give the just little bit of differences and maybe the bit of its impact if that's maybe can help maybe one, but I wouldn't say how it was changed. I can just help on where the difference could be and what maybe impact that it has. Maybe I can just take you through to that.
Yeah, just 1 minute. If you can do that within a minute.
Okay, with the old form, compliance differed from the current form in terms of now we lodged the claim based on the compliance as per to the Section 24 of the RAF Act, not the additional, I think I'm correct, is Section 24, not on the additional documents now that medical experts, that's your medical legal reports, are now part of compliance documents. So that differed. And two, we had an SMR. And SMR allowed for us to lodge the claim in direct claims. We could lodge the claim without the medical report, and that could always follow later, and that simplified the process for a layman. Now, you're looking at now the issues that it brings now, the impact that it has. You have a requirement that is costly, that is now part of the form, that it can't be accepted without those requirements. You are looking at, for instance, it needs to be accompanied by RAF4 form, which then that particular form as well, it needs to be completed by a doctor that is been trained on AMA Guide. And that form alone, it will cost anything, I think, over 6 to 10,000 rand alone, that form. The medical legal experts, they will charge anything 15 to 20,000 or 10 to 20 something thousand each person. So now it becomes costly for a person that's just been in an accident. You don't have a budget that is 50 to 100,000 just for you to support your claim, which now this makes it, for the attorneys, it's okay because they have been doing that anyway. Now, the issue of question is, how do you confirm that I can bring in medical experts report when the RAF has not confirmed liability? Do you allow a person to incur costs before you confirm liability? Now, in the past, we lodged a claim with the minimal compliant documents. RAF will do its merits, confirm liability, then the rest can follow, because now we know that the claim will be paid. So now if it's part of the documents, it's just that bit of, I'm not sure why, but yeah, there's that difference now.
No, I get you. And then with regards to the, what do you call them? Claim handlers, yeah, I think you're saying claim handlers, because after the termination of the panel of attorneys, claim handlers had to inherit some of the responsibilities that were done by the panel of attorneys that had to handle a lot of claims and what. I mean, I want to find out as to, during the time when there was still a panel of attorneys, what were the roles of the claim handlers, which is now different after the dissolution or the de-establishment of the panel of attorneys?
I wouldn't want to respond based on speculation or assumption, because I was not in the department, even though I was part of the forums where we're discussing performance efficiencies. But in terms of the actual co-production, the output of what they were doing or the inputs, I would like to be pardoned not to directly respond on what actually they were doing at the time, because I was not part of the team.
Okay, no, that's fair enough. And then the operation, project Shanyela, because I think some of these, the work that was outstanding in relation to the direct claims, I think it was then given to that project Shanyela. Did the project Shanyela manage to process those claims to finality?
That's another issue, Honorable. I was not part of the project. In terms of how it was being settled, and when I left the organization, we're still busy with those claims. So in terms of its status currently, as far as I know, when I followed up, because I still get calls from the clients that we assisted in then 2013, 2019, 2020, 2019. So I still get those inquiries. Then I will escalate to the team inside, and I will be told that, those claims are no longer being processed and we don't know where to go and what to do. So there are claims that are outstanding, of course, that I can confirm, because some of the claims, as I stated earlier, we lodged them, they were outstanding documents, because we were on the ground to collect them. But when we stopped, we had no other ways of trying to save those files and ensure those claims are settled, because now those claims were at direct claims, then moved to Project Shanyela for finalization. So I know that they use some of their resources to try and call the clients to bring in the files, but mainly they were not materialized, because I still get escalations even now as I'm outside. Where is the claim? Because we're out there as the face of the organization. So people have our direct contact numbers inside the country and outside the country. So I believe that it's not all claims that we finalized. There are still those that are still open.
Okay. Yeah, my last question, Chair. Who was the ER manager, the one who was responsible for the suspension, charging, and firing of people without following processes? Who was he or she?
ER is centralized in a way at head office. It's under Ms. Nonhlanhla Dludla currently. At the time, it was under Mr. I think it's Mutloding. And yeah, and the Mutloding, right? It was the senior manager then at the time. Yes, and then the manager was Mr. Walter. So they were in head office, but they had ER specialists in all regions. So in Joburg, mainly in Cape Town, Durban, there will be ER specialists that are based in the region, but reporting to their management in head office.
Are they still in the employment of RAF, Mr. Mutloding and Mr. Walter?
No, the two are not. Ms. Dladla is acting as senior manager in the space of Mr. Mutloding.
When was Mr. Dladla appointed, do you know? As an acting?
When I left the fund, she was already acting.
Which was in 2023?
Yes.
Oh, okay. All right. Yeah, Chair, I don't know. I think I would propose that we get this Mr. Mutloding and Mr. Walter, or if possible, also Mr. Dladla. Yeah, those are my questions. Thank you very much.
Thank you very much. I think we are likely to get imminently their boss. Maybe we might get assistance there, but I agree with you. Yeah, we need to get some answers. Yeah, we need to get some answers. Thank you. Honorable Bila.
Thank you, Chairperson. Good evening to Ms. Tetwa, Mr. Phillips, Reperili, Advocate Kalanga.
Abshen.
Minja.
Forgive me,
Go. It's Honorable Maduna who taught me that when there is someone who is from your area, you take that advantage of talking in or using your own language.
I saw him operating yesterday. I've stopped the clock. Did you notice? Did you notice with Mr. Hubbard there? He was busy operating.
Yes, he was. No, thank you so much. My first question will go to Ms. Mtetwa. In paragraph 10, you said you were seconded to Johannesburg region, where you were going to deal with legal matters. When you are relating the story to us here, you said you were afraid because you don't have knowledge of legal matters, but you end up accepting the offer. What made you to accept that position, whereas you know that you don't have legal qualifications? Did you accept it under duress, or someone was holding a gun for you so that if you don't accept, I'm going to kill you?
Thank you, Honorable Bila. No, there was no gun over my head for me to accept the responsibility. I got to the region, I saw the mess that was shown to me by Miss Morgan. At the time she was acting, she had to move to act as a regional general manager because that position also had its own problem. There was no one permanent as well. So there was a consultation with the COO, acting COO at the time, and the senior manager of support services in the region. And of course, on the ground, there were no resources because almost every position, there was an actor. So yeah, there were those problems that I saw as a manager, as much as I did not have the litigation or the legal qualification. But in terms of managerial expertise, I have that, and it's something that I could help the situation if it's dire. So the leadership committed support on my side based on where I lack. and I needed to assist them with the aspects of managing the issues, as much as it still included assisting with the transformation. So I accepted because there was a commitment from the acting CEO and the senior manager, including HR, that I will be supported where I need support, and I will be taken through until I can actually run with the space. So I then accepted based on the fact that there was a crisis, and as a manager, I can't just sit back and say, I do not have legal degree, when actually 80% of the functions I can't do. It's only just the minor part of the legal degree and legal experience. So that's the reason I accepted the challenge. Sorry.
No, thank you. One other question to you. I want to check with you if you have an estimation of the number of direct claims which prescribed in the hands of the Road Accident Fund between 2014 and 2020.
No, ma'am. I wouldn't have the number of direct claims prescribed. I think, as I mentioned earlier, I was responsible for the lodgement of claims, not the finalization of claims. So I think the person that will have those answers will be the manager in direct claims that was actually responsible for that. He was actually here, Chair. I think it's Mr. Chaka, Debuho Chaka, on the first day. That was the manager responsible for direct claims, which will have actually the accurate states. Thank you.
That's a gentleman who was using a complicated term for a leg. You remember, Honorable Pila? Yeah, that one.
I remember, Chair. Let's go to the matter that you raised in paragraph 41 to 42.
I'm the Honorable.
Yes. I just want to check with you the criteria that was used in selection of the 95 hospitals that we were working with.
All right. 95 hospitals. I wouldn't comment on what criteria was used because I was not at the fund at the time. When I came in, they were just actually establishing those offices. They had already identified the way they're going to place the CSCs, which is the customer service centers, the hospital service centers. So that was all identified, and the recruitment process had already begun. So when I came into the fund, I came in with all those staffs together. It was just that mass recruitment for those offices to function. But what I can comment on will be these offices, the hospital service centers, this 95 that when I came, they were also open in 2014, between 2013 and 2014, but we all started operating then. They were in the areas that are in the outskirts, very far away from the regional offices or major cities where they can access the RAF services. So they really served people that are in the most rural areas and very far to access services that were existing prior to opening of these offices, which were hospitals that are in all areas that you can think of, as well as our customer service centers that were far away from the main regional offices that existed prior to opening of direct claims.
You were in Limpopo, but Malamlele was not part of those 95 hospitals, and it is also in the very rural area there. On a lighter note.
No, ma'am. We had an office, an hospital's office in the Malamulele Hospital. What's the name of that hospital? Just behind the mall. There is your main hospital. We had an office there. We had a consultant there by the name of Dick Maluleke, which was the consultant that was based there.
Honorable Pila is your relative.
I think so. So I can't go on asking that question because it's the Maluleke who is employed there. So can I check also with you, in your opinion, were the hospital-based offices efficient and enabling claims to be initiated quickly before the victim left the hospital?
Definitely. Based on the figures that also shows that in 2014, 2015, when we started that first year, we had already lost 22,000 claims. Those are the people that we accessed immediately after the accident has occurred. It's not like people that had maybe the ones that had accident like years ago, maybe before the claim prescribed, it can just be 5% of that portion. But we definitely, it shows by the time we closed 2019, we were already at over 40,000 on direct claims that were lodging within these HSCs. So definitely there was an impact. It was growing. I wouldn't stay away for the fact that there could have been gaps that could have been closed. But in terms of our effectiveness on the ground, definitely we'll go to accident scene, we'll go to the bedside. It didn't matter whether it's Sunday or midnight on a Wednesday, in the following day you are going to hospital. If there is a crisis on the road, we ensure that there is information readily available. So definitely they were effective and efficient.
Thank you so much. I was having a question on Project Shanyela. So you said you were not part of that project. So let me skip that question because I wanted to know when it was introduced and the objective beyond. Let's check paragraph where I saw the mass funeral thing here. It's paragraph number 54. Where it is indicated that in the case of mass accident, RAF personnel ensured full support. It only takes 3 working days for the payment to be finalized to the affected families. So how are you taking long for the other claimant to be paid, whereas it is doable that it can be done within three working days?
Thank you, Honorable. The funeral claim, it's much quicker to settle. You only need the confirmation of death certificate, which the family can receive within 2 days as soon as they report it from Home Affairs. You need an ID copies of whoever that is going to be claiming and the deceased and the form. That's all you need. Then the claim and the invoice from the parlor, a pro forma invoice from the parlor. That's all you need to claim for a funeral claim. With the other claims, you need a person to at least reach MMI. That's the confirmation that the serious injury is permanent, and that takes at least 12 months. However, based on what my colleague mentioned, Mr. Brett Phillip, in the past, as he said, they could settle this claim before even they receive summons. That's within 120 days. So it goes down to the very same issues of, with the other claims, the issues of capacity that he mentioned. So certain things, the fund eventually focuses on the agency more than actually what can be contributing positively towards the performance of the fund and its mandate. So those are other issues that just became bottlenecks. But other than that, it is possible, provided that there is the right capacity in the right places. Yes, on claims that can be confirmed, like for instance, you don't need MMI to a para or a quad or an amputee. You know, those claims, you already know this person does not have a leg, so why should you still wait? But looking at capacity, then it might become impossible.
Still safe?
Honorable Pilar, you are always safe.
Because I still have 7 minutes, 7.5 of yesterday.
Please carry on, Honorable Pilar. You're the one member, you can be indulged.
Kalanga, There was this issue of double payment in the ref. I don't know whether you were there when it happened or when it was happening. Can you tell us about the issue of double payment?
No, I can't speak to that, Honorable Beer, unfortunately. It's not in my space at all.
Anlovona ku mi nga fambi ni nga mi vutisangi nchumu mi nga ta ku na hlola.
Nkomo.
Mr. Phillips, you said you are pleased that on the 1st of November you are going to, or you have finalized the recruitment process. Am I correct?
Honourable Bila, there is some recruitment process that is completed for certain positions,
Okay.
where successful candidates are starting their positions on the 1st of November.
So what will please this committee the most is to see our communities or the affected families being compensated by the ref. So make sure that when you are pleased by the people who are coming to join you there, then you do the work so that our communities or our affected families can also have what is due for them. Go and work so that RAF must come from the first page of the newspaper, because you are always on the front page. And even in the radio, when they say the headlines, it's only maybe at 7 o'clock and 8 o'clock when they will say this is the headline. But at 9 o'clock they change the subject. The other headlines comes there. So you can't be, it can't be rough for the rest of our lives. Let's go and change. Let's work and reduce the backlog that the RAF is saving. You have our support as a Scopa. Thank you so much.
Noted, Honourable Bila, and thank you very much.
Thank you very much, Honorable Bila. I still believe you time yourself because you always bang on time. Thank you. Honorable Beasley.
Thank you, Chair. Just to confirm, we got 15 minutes, is that right?
Yes, it's 15 for 20, by the way. I always indulge all of you, because if I say 20, then it's 25.
Starting off with Mrs. Mpetwa with the direct claims, I understand the logic behind the direct claims, and it makes perfect sense in a country where we're wrecked by poverty, inequality, access to resources. So direct claims definitely seems the way to go for various reasons, and you can just confirm if my thinking's right. First of all, from a financial perspective, because there's less lawyers involved, so there's more money to go to the claimants. And also, if people get immediate treatment, it actually saves costs in terms of future treatments, and I think that's very important. Then secondly, emotionally too, we can't always just put a price tag on people's medical things. It's emotional too. I can just picture my mother being involved in an accident, and she goes to the hospital and somebody's there from the RAF to walk her through the process. If you had to tell my mother she needed to go to a lawyer, she would have to take tranquilizer tablets before she goes there. And I think that's the experience with most people. So there is definitely an emotional side to direct claims. And then thirdly, and I also think very important, is access to urgent. If we're going to treat people, often the sooner they get urgent treatment, the better for them long term. And that's what RAF is about, you know. So am I correct in summarizing the rationale behind the direct claims, and if I'm missing anything out?
You are correct, Honourable.
Thank you. So understanding that, what is the logical reason for changing that strategy? I'm trying to understand if these are all the positives, what would be the reasons to do it in a country where we're wrecked by poverty, unemployment, you know, access? So what is the logical reason behind stopping the direct claim? Well, not stopping them, basically stopping them.
I wouldn't comment on that, Honourable, because I have no idea what was the logic on the closing.
Neither do I. So, And was there a plan in place to saying, listen, we're going from direct claims to non-direct claims? Was there a plan in place saying this is how we're going to do it?
The experience on the ground, there was no plan in place.
Yeah, I get that. And the word that I would use from your affidavit is chaos.
That's correct.
And in this chaos, who would be the ultimate losers?
It's the beneficiaries.
Thank you. And I think it is quite evident in the direct claims that the statistics that we were sent earlier. In 2018-19, direct claims were 36,000. Current year, it's dropped to 2,800. I mean, if you work out percentages wise, it's about 85-90% drop increase. And it's quite interesting that the RAF say they're wanting to save legal money, but direct claims have gone from 35% to 14%. So it means representative claims have gone up. So there's more litigation involved. So it just doesn't make sense. And I think you said it spot on when the losers in all of this are the claimants. So thank you for that. And I also just want to commend you on your passion. It came through in your affidavit. It came through your statement that you were there for the people and people like my mother. So I thank you.
Thank you, Honourable.
And Mr. Phillips and Mr. Beloy, I also appreciate your passion, but I'm probably going to be less gentle as I was. Are you aware of a cost-benefit analysis done with regards to the removal of the panel of attorney?
Honourable Beasley, no, I'm not. As I said, I came into the model 3 years after it had been implemented.
Mr. Beloy, you were there?
Chair, as I said, I was working in panel management, but I'm not aware of such. I'm sure it happened, though, at a higher level than where I was.
Yeah, we've yet to see that. And then in terms of, obviously, was there a plan in place to say we're going from this to that? Was there a plan in place to help people along the way to say this is what we do? Was there a plan in place?
Once again, I'm unable to speak from personal knowledge because by the time I arrived into the model, both from a perspective of the Johannesburg regional office where I was litigation manager, and then subsequently later, the state attorneys were already there.
Okay, I appreciate that, but Mr. Beloy, Mr. Mthetho, was there a plan in place? No.
Chair, I think there was a plan in place. As Mr. Phillips said, the plan was the state attorneys. I know we had been engaging the judiciary quite extensively, as well as plaintiff attorneys, informing them of the change that was happening in relation to the panel and the shift towards an operational model that had litigation in-house.
I just want to read to you the SIU's findings. It says, sorry, I'm not too... There was no plan adopted to replace a panel of attorneys. So the SIU's finding that there was no plan. So there was no plan unless we're questioning the SIU's findings. And then just Mr. Beloy and Mr. Phillips, what is the mandate of the RAF?
Chair, the mandate of the RAF is the compensation and rehabilitation of road accident victims, essentially.
So what would be the number one key performance indicator?
Settlements of matters, payments of claimants, and assistance with rehabilitation, I'm assuming.
Yeah, I mean, I think we would all safely say that. So it's not actually the line item legal fees. And the reason why I say that is, you know, I ran a factory for many years and electricity was a high cost. But if we'd reduced electricity by 30%, which you've done in the legal fees, as directors, if we were high-fiving each other for the reduction in electricity fees, but our output dropped, that would be stupid. So I'm saying, wrong word, it wouldn't make any sense because we're trying to reduce electricity, but we're shooting ourselves in the foot. And I'm saying that's what on the numbers it actually appears to me that you guys have done, is that you've focused purely on reducing the line item of legal fees, but your output, your number one key KPI has gone backwards.
Chair, I'd say that would be correct, but I mean, any of the example that you've used of the factory, if your turnover is R1 million and your electricity bill is sitting at 900,000 rand. How long can you sustain that for?
Yeah, with all due respect, your legal fees weren't at 90%. They were at 10 billion. I mean, and you're on a 50 billion organization, and you're in a litigating environment, so it's an important cost factor. But you can't reduce it and reduce your output because you go out of business. And I just want to give this is, to me, that it's a classic number. Your legal costs went from 10 billion to 7 billion in 4 years. But your claim output dropped from 258,000 to 63,000. So if you divide your legal costs by the number of claims, it's actually gone up by 3 times. So your legal cost per claim has gone up from 39,000 to 111,000. So that actually says that the thing has actually not worked, because your key performance indicator, your number claim, has gone from 258,000 to 63,000.
Chair, I think I'll allow Mr. Phillips to come in on that, because in terms of the numbers, I think they're in his presentation, and I think he can speak to what that looks like in terms of the numbers that we have.
Thank you, Chair. I think from the perspective of reduction of legal costs, obviously the annual report indicates what number of claims have been attended for that specific period. And we are also looking at an increased amount of litigation around the board notice 271 issues. But your point is noted in terms of the reduction of legal costs over an extended period of time.
And with the amount of claims going from 258,000 processed in 2020 to 63,000 in 2024, who were the losers?
In terms of the board notice itself, remember the organization from an operations point of view is not registering non-compliant claims. So if there is an entitlement to a claim and the claim is settled, obviously the beneficiaries are the winners in that process. Further than commenting around the reduction in the number of claims, which is really an operations issue, if a claim is not registered because it's not compliant, it will be registered when it becomes compliant, and then obviously the process can ensue from that point on.
Are you not concerned that there are many claims that you deem not compliant, but the court actually deems compliant because they've ruled that the board notice is illegal? So there's massive claims building up outside of the system that you guys haven't registered.
Honourable Member, I wouldn't want to comment on that. That's really an operational issue. My space is obviously to do with the state attorneys. I think that would certainly be a question that colleagues from operations would be able to address.
No, I appreciate that. And then you mentioned the state attorneys. You've got a huge vacancy. I think you said there's a 353 posts and you filled 108. I mean, why is it taking so long? And I think you've answered the question. I mean, if there was a sense of urgency about this, then there might be a bit of more empathy from us. But there's no urgency about it, because if the number one priority was paying out claims, that should be number one priority. It can't take, and I think Mr. Beloy said, oh, it's an infancy. It's been going on. The panel of attorneys has been gone 4 or 5 years. I mean, these posts should be vacant, and if they're not vacant, there's a big reason why they're not vacant, why they are vacant.
When I commenced in this position in October 2023, there were 108 filled positions. We now have 149. Obviously, the 137 currently, and there's provisioning to the 149. So I would like to think that we have done what was fairly possible in the recruitment space in the last 24 months. But we are certainly, as I indicated earlier, we are recruiting on a daily basis virtually.
With all due respect, Mr. Phillips, I can't agree with you, because if there was an urgency about this, you can't go from our full 20, 30 positions in 2 years. You know, if your number one priority is getting claims done and sorted. There's just a lack of urgency. You're painting a picture that's not really the reality. There's just a lack of urgency about it. Yeah, Chair, that's just the one interesting thing is Mr. Beloy earlier said that, we spoke about the average claim going up from 114 to 268,000. Mr. Beloy used inflation as the reason, and then you said it wasn't inflation, it was because more professionals have been involved in the accidents and now more children involved in the accidents. But what's quite interesting is we did an estimate, or I put an estimate on the table, and it was supported by the previous actuaries from the Road Accident Fund, and it was based on the claim value of 138,000. Now you're saying it should be higher because of reasons. That actually takes that 500 billion unrecorded liability up to 1 trillion. So it is actually quite scary. So if what you're saying is actually correct, the actuaries are going to have to redo their calculations, because the claims are going to go, the unrecorded liabilities is going to go from 500 to 1 trillion. Chair, I'll end on that. Thank you.
Thank you very much. Can I get some clarification, Mr. Phillips, because there is something in your language that confuses me around the vacancies. So, are you in charge of your staffing budget?
Chair, to the extent that we have a budget which is provisioned for the department, yes.
Getting there. So, how many positions does it allow you in this financial year?
Chair, if I was able to, I would be able to capacitate the structure if I could.
No, don't try and think where I'm going. I'm asking a different question. How many roles are funded in this financial year for you, in your structure?
Chair, I would have to revert on that. It would be something I would need to investigate. But in terms, all of the roles are budgeted for, in terms of the structure. So when we recruit on the system, they are indicated as already approved in terms of the budget.
So when you say provisioned, what do you mean?
So, Chair, I've indicated on my presentation, provisioned means there has been a recruitment process. The person, the successful candidate, is due to be starting obviously shortly. Alternatively, there has been a recruitment which is completed and we are waiting psychometric results back.
So, Mr. Phillips, where I have difficulty, so I think like many members here, I've managed people for a long time. I knew what my staffing budget was. I really did. I expect you to know it. Your salary bill, I mean, you know a couple of things. You know which positions you can fill in this year, because in the budget, there's financial provision for it. This question is important because the members are developing an impression that there is budget available for 300 and some odd roles and you are moving too slowly. You see what happens. Do you understand? So the reason I'm asking you how much in the budget for this financial year is accessible to you, because you can't hire beyond what is budgeted. So I expect you to know what the limits are in terms of how many people you can hire, how many advertisements you're going to put out. I am stunned that you don't know. And I'm talking to Mr. Phillips now. I'm talking about his role. He's the head of his portfolio, right? You're responsible for state attorneys. If you miraculously could, if we were to create AI tools or whatever, and you could hire these people in this financial year, how many would you be able to hire?
Chair, I would have to revert on that information because in my understanding, all of these positions are budgeted for already. And when recruitment begins, there is an indication on the system that the position is pre-approved. So it's not a new position that we are adding to the system. It's already budgeted and pre-approved.
So, Mr. Phillips, budgeting usually works like this for staffing. So I'll get an allocation of, let's say, 8.9 million for salaries. And somebody's resigned. And we battle to find somebody for a period. that accumulates as a credit on the salary line because there's each month where you're not paying anybody for that. So when you get your monthly reports, your monthly financial reports for your entire department, there's all sorts of things. It's like, imagine the litigation costs, there's all of this, and one of those lines is salaries. And I know that at the end of the financial year, if I don't fill this role, I might have saved like R1 million out of that 9 something odd million because I haven't had the person in post. I would be able to know that. What I'm surprised by is that you have no idea. This is what was the implication of what you're saying is that the Road Accident Fund could, in its budget, have provisioned 85 million for hiring. You're only utilizing 35 million of that. And each year it rolls over unused. That's what I'm trying to establish here. It's no mystery. So I'm trying to understand why you don't know.
Chair, as I indicated, my knowledge extends to the fact that these positions are pre-approved in terms of budgetary provisions.
That line actually makes it worse for you. It doesn't help you. Because if they are pre-approved, then you have the number because they are pre-approved. You do. You must have the number. They are pre-approved. You don't need to go back to anyone and ask for approval. The money is there. But you don't know.
Chair, I will have to revert on this at this point.
Yeah, but that means you don't know.
Correct, Chair. I will revert.
Okay, Sir Phillips, that's worrying. Okay. I really think you ought to know. Yeah. Let me deal with this when Honorable Atkinson is done. These other two questions I have. I just felt, let me just clear this up. Because, honestly, we don't want... So let me tell you why this is important. If we ask that you be given more money, if I'm the chief, if I'm Bernice or Berenice, if I'm Bernice, I'm going to say, I'm not going to give them more money. They never spend the one that we've allocated them because they're not hiring fast enough. As an example, you see what could happen, right? So we make a recommendation that you get more money, but you're simply physically not able to hire the people. That's the problem. So when I'm asking you how much is allocated, I'm trying to establish if there is a budget constraint of sorts, and it appears from what you're saying there isn't one. You're just struggling to find the people. That's fine. Mr. Malawi, I just want to get here on this thing about there being a plan. So you said earlier, and I'm going to come to you, Honorable Atkinson, now. You said earlier that in our previous exchange and with the other members that you're still filling out the roles, right? You know, the whole state attorney thing is a new model, and the capacity is not yet all there, right? Don't you believe that somebody who's trying to do this properly establishes a rate of de-escalation on the attorney's side and a rate of escalation on the state attorney's side, such that nothing falls between the cracks, right? So in other words, you start with 500-600 warm bodies on the attorney's side. Over a 5-year period, you reduce that to 0, but you also give yourself 5 years to scale up on the other side to 600. That would be sensible, wouldn't it?
Chair, I suppose that would be sensible. Obviously, the way it was done, there were some teething issues, and obviously hindsight is always best.
No, it's not hindsight, by the way. It's proper managerial application of managerial responsibilities. It's change management. Then you wouldn't have the problem that we spoke about earlier, where you don't have attorneys to attend to matters. This is not rocket science. We've all done it. At least some of us have, right? When the SIU says there was no plan, that's what they mean. They don't mean don't do it. They mean don't create gaps in the system such that you end up with no attorneys. You shouldn't be still trying. This decision was taken when in 2020, right? It's going to be 2026 now. Mr. Phillips is still sitting at how much occupancy? You see where we're going. The application of that decision was poor. Exceptionally so. Because you can't leave your own process starved of resources because you want to just cut the umbilical cord suddenly. This is not about fighting for anyone. It's about the claimants who, you know what I mean, and the road accident fund. And we're going to talk about costs just now. So I just wanted to clear these two things up for now. When I do my own bit, we're going to work through some issues together so that we can work through some of the things that were said today so that we're just able to understand the conclusions that we reach. Honorable Atkinson.
Thanks very much, Chair. Just a question for Mr. Phillips. You did your kind of back of the cigarette box sums a little bit earlier where you said about, I think it was probably about 200 advocates or slightly more. It was about 230 advocates, I think, that you'd required to be able to operate properly. Now, we do know that you are not dealing with what you term non-board compliant. So you're not dealing with stuff that is not compliant with the board notice as it is. But apparently stuff has gone to court and there have been default judgments on what you would term non-board compliant. So things that actually comply with the RAF Act, and that there have been default judgments. So the question I'm going to ask you is, if the minister finally says to RAF, you've got to follow the accounting policy that is mandated, and the RAF 1 notice as it is illegal, which it is, and you need to revert back to the system as stipulated in the Act, how many more attorneys do you think you would need? And I know this is probably just something off the top of your head, but I mean, you know, I think it could well cause a huge problem. And I was just wondering what your view is of the extent of that problem, basically. Yeah.
Thank you for the question, Honourable Atkinson. I did factor that in the presentation that I did. The summonses were divided into registered matters, pre-assessment matters, and the colloquially referred to as NR matters. So I factored in the full range of summonses across all of the sources when I looked at the figure of possibly 204 additional state attorneys on the structure.
Okay, thank you. And if you forgive me now, because I'm going to be asking someone else's questions, the Honourable Isak, so I'm just going to have to read some of the stuff to you.
Hope you can make out his handwriting, because I tried to have a look and I thought, jeez.
Yeah. Sorry, just give me a moment. My colleague's got doctor's writing. Yeah. Okay, so Mr. Phillips, a question from Honourable Isak says, if settlement matters were a priority, why are so many matters on trial? Okay. Simply put, don't you settle them mid-process to avoid long and expensive adjudication in the court, basically?
Thank you for the question. Absolutely. So the settlement part of the process is done within the operations environment. So the operations teams are responsible for assessment and settlement of the claims.
Okay. He says, what is your motivation for using paralegals? He said, surely you actually need to have experienced practitioners.
Thank you for the question. I indicated that the structure provided for support staff in the form of drivers, messengers, legal secretaries, and paralegals. We have very qualified paralegals. In fact, 90% of our paralegals are admitted attorneys. That might not always be the case as we extend the recruitment, but the point was with the paralegal level that you want a slightly higher level of support given to a state attorney in terms of possibly doing research and preparing legal documents, etc. So that's how we factored that in.
Okay. Sounds very much like Mr. Esaki says, with due respect. Yes. Yeah, his favorite line. I do not comprehend this state attorney. Sorry.
You have to make a call about whether you can make out this handwriting or not.
I'm going to leave that one. I'll ask.
Yeah.
So with due respect,
ask the ones you can see.
Yeah, with due respect, I can't read your writing. Yeah, anyway. Did you listen to Mr. Charakupa's presentation last week when he was here before the panel?
I didn't.
Right.
I'm afraid I didn't.
All right. So what he's saying is, how do you litigate on matters with outlink numbers? Those are the matters that are not board notice compliant. And I think we probably have covered that to a degree. I don't know if you want to say anything else further about that.
Nothing further.
Are they taken into account at all in any way? Things that are not board notice compliant.
So in my presentation, you'll see I included, as I indicated, registered pre-assessment and the NR matters.
Okay. All right. Oh yes, and this comes to the prescribed claims. These the direct claims and the matters that prescribing says, should the Road Accident Fund not hand these matters over to the LPC to assist these victims? You see, you are aware that they are that they can only be revived by serving summons against the RAF. So in other words, what he's saying is. As we heard from Mr. Harbin's comments, do you not think the RAF should actually come to the aid of those people that were direct claimants that have their claims are prescribed, basically, under your earlier system?
That's on the prescribed claims in the hands of the RAF?
Yeah, I'm talking about the direct claimants, the people that came directly to RAF. So, people that came via lawyers, obviously the lawyers then would serve summons.
Yes, that's correct.
Mm-hmm. But there were quite a lot of people that came to you in good faith. And at some point, if the RAF hadn't kind of kept them alive, they would prescribe, and the people involved might not know about it. So effectively what he's saying is, don't you think that there should be some assistance to those people who have had the claims prescribed through no fault of their own, because they didn't realize, they didn't have the legal knowledge to know that summons had to be served on RAF for their claims to stay alive. What he's saying is, shouldn't there be some move by the Road Accident Fund to actually help those people? And I suppose get a lawyer to serve summons to try and keep those alive. So he's talking about, I suppose, a level of altruism, really. Yeah.
I totally agree. We robustly went out there to get these claims and made commitment. So if we know the rules out there about the client and the supplier or the customer-client relationship, you make a commitment, you need to deliver. If you get to the shop, you find that there's a tag of 5 rand, you can come out with that 5 rand, even if that product was 1,000 rand. It's a commitment issue to a client. So I believe that the organization needs to have, I don't know how, because now there is laws in place as well that are against a prescribed claim, which is guided by the Act. So I wouldn't know what's the plan. But there should be a plan that the fund should not incur further costs to try and litigate those prescription matters, because at the end, I do not think we'll be in a space to win that case. Because we went and lodged a claim and we sat with it and prescribed in our hands. So litigating it so that you can rely on the court judge, on a judge's decision to do the right thing, I think it's just will be wasteful expenditure.
Sure. Okay. And then for Mr. Beloy, with your comment about the black and white children, Mr. Isak says, is there any case law that would differentiate between black and white children?
Chair, through you, I can't say off the top of my head. I'd honestly need to check, but I'm certain that there would be. But that's just me anecdotally, I think, saying what I think, but we'd need to check on that. But I'm sure it does exist because, I mean, it did go to court at some point to say whether or not that was constitutional.
Thank you. And Mr. Bloy, why did you advise people to apply for positions they occupy when you did not have the authority to do so?
I'm not entirely certain if that question is for me, Chair, because I don't work in HR or human capital, and I don't make those policy decisions. I mean, this thing affected all of us, so I'm also sitting here as one of the affected people.
Sure. Okay.
There is a provision on the system for summons receipts. So the statistics which I've given relate to the summonses linked to the NR claims. There's no claim registration on the system, but the summons receipt is acknowledged.
Thank you, Honorable Isak. Thank you, Honorable Isak. I must say, he sent them to me as well. I gave up after a short while. I thought, ooh, okay, I hope he's not watching. Yeah, he'll be very disappointed in me. Thank you very much. So I'm first going to just ask for your assistance, Mr. Phillips. This document that I'm going to ask you to look at, you did not send it. Your colleagues at the head office did, but you were counsel before. You would understand this thing. So please consider this to be orientation. Do not laugh. I am going to ask you a couple of dumb questions about how costs work. So you see there is this little table here. It's about 60-70% in this table with plaintiff legal costs, sheriff and writ costs, interest costs, rough legal costs total. Can you see that? You're just going to explain concepts for us, nothing more. I just want to make sure that. So on this new thing that has got Judge Sutherland's thing at the front. So I was actually hoping each document would be bound separately so you could just pick it up. So there is the judgments, and then there is the legal service court monitoring response document. Go past it, and then immediately thereafter there is a table that says at the top, value of legal costs paid by category, product, and period. Can you see that? Yes, okay, thank you. If you can just assist us, I'm just trying to understand what these things mean. So, plaintiff legal costs. So, I'm assuming that the matter went to court because it says advocate claimant, right? So, the matter went to court, and 2015 to 2016, 2015-16 to 2019-20, the number was 3.4 billion, and 2020-21, the number was 3.6 billion. Can you just explain that? So, is that so? Does the RAF, as a matter of course, also pay for the claimant's advocate and attorney? Or in which instances does that happen? And this is really not a trick question. I'm asking in all seriousness.
Chair, thank you for the question. I'm going to obviously indicate that there isn't a breakdown here as to whether it's trial process or TIC process. So from what I'm looking at in terms of the grid presented, there would be advocate costs linked to a process, whether it's trial process or trial interlocutory court process. And obviously then there's an attorney, the majority of the costs in both of the grid years are for the attorney, and then there's obviously also correspondent costs linked to the service within the court's jurisdiction for the plaintiff itself.
You know, I appreciate that. What I'm just trying to understand is, and this is where I'm embarrassed, why is the RAF obligated to pay also for the claimant? I mean, can't the matter be settled and then from the settlement or from the judgment, then the claimant pays their lawyer? I'm just trying to understand why it's put on you.
Chair, the rule of law is that the successful litigant is entitled to his or her party and party costs. Remember, there's various scales of costs. So that's obviously the principle is that if you've succeeded in whole or in part with your claim, you're entitled to the legal costs that attach to the success of the claim.
Oh, I see. So we could just say this happens as a matter of course. So when the litigant is, so in other words, when the claimant is successful, then it's no bad reflection on you as a RAF. It basically says that that's just how the cookie crumbles in court, basically.
Or, Chair, if the matter is settled, obviously there's an attachment of costs if the matter is settled by agreement between the parties without necessarily going to court. There would still be party and party costs attached to that settlement.
Can you explain party and party costs?
Chair, there's obviously various scales of costs. A party and party cost scale is the scale of costs between one party and the other party. So a plaintiff is one party and the RAF is the other party. Then you get attorney-client costs, which is a slightly higher level of cost. That's the cost between the attorney and his client. And then you get attorney-owned client costs, which is the highest level of cost scale.
All right, thank you. And then the correspondent attorney is basically the attorney in Joburg, who handles, basically does your filings and all of those lovely things. Those would be correspondent attorneys, in that you don't need to travel there, basically.
That's correct, Chair.
Okay, I get it. Okay. Sheriff cost. Can you explain that for us? What's sheriff cost?
Chair, this is the cost attached to the sheriff executing on a warrant of execution. Obviously, there's two levels of costs. One attaches to the cost of the writ itself, and then obviously the costs of the execution of the warrant of execution, which is done by the sheriff of the court.
Okay, so the sheriff gets involved when it's desperate times. The matter has been, the court has given at least one order before or two. And now there's the sheriff has to come around and fetch some desks and computers.
That's correct, Chair.
Okay, and so I can see this problem used to be huge, 136 million. At least it's now 46 million. Okay. Can you help us with the writ cost?
Chair, I'm speaking under correction, but I think it's a cost that attaches to the writ being processed by the sheriff, but I'm speaking under correction here, Chair. I haven't seen a warrant of execution in a while, but there is a provisioning for that.
All right. No, thank you very much. We're nearly done with this table. Then we will move on. Interest cost. I see the RAF 2015 to 19 paid over $1 billion. 2020-21 to 2024-25, it's close to $1 billion. What is that?
Chair, once again, this provision would be for interest either on unpaid capital or unpaid costs. So there isn't a breakdown here, but it would just be a globular figure for that.
That's fine. When does the interest start ticking?
Chair, it would depend on what the content of the court order is, if there's a court order, because obviously the court order determines the provision for interest.
Okay, so let's say Honorable Kupeka here has won his claim in court. Do they start calculating interest immediately?
No, Chair. There's provision for interest on the day number 15 in terms of the Road Accident Fund Act. But as you know, Chair, there has been the 180-day processing of payments in terms of the provision for interest. But once again, it depends on what the court order says.
Okay, so I'm assuming that, when in the days of 180 days, which has now expired, I understand, it just means that upon expiry of that period, when the claim should have been paid, then the interest now starts accumulating. I'm assuming.
Chair, there's the concept of what is called mora interest. So if you elect to agree to a payment period outside of the Road Accident Fund Act, and you don't pay on the date that you're supposed to pay, then you start accumulating what is called mora interest. So it's delay in payment interest.
So it's supposed to incentivize you to pay,
on time.
Otherwise on time. And an organization that accumulates that kind of money, okay, we will have that conversation with somebody else, I get it. So can you just help me? So there it says now from 2020-21, for the RAF now, advocate, agent, attorney, etc. Before you used to have those costs. But now since 2020-21, that is zero. Can you see that? Does that sound realistic to you? In other words, between 2020 and 21 until the end of this financial year, this past financial year, the RAF paid no legal fees. Can you see that?
I can, Chair.
Does that sound realistic to you?
So, Chair, obviously these figures are drawn from the system. This is obviously drawn from a payment system in the organization. In terms of provisioning for advocate agent and attorney agent, correspondent attorney agent, I think this is obviously the definition in terms of the system configuration. But there certainly has been a payment process for counsel that are briefed by the Office of the State Attorney.
Yeah, this doesn't appear to be complete. I mean, it looks like they either don't have the information or they've withheld it. Because the way I read it as a layperson, it says the RAF had no legal expenses for the last 5 years. Because here, in the previous period is provided. In the next 5-year period, there's nothing. I mean, as a layperson, if I read it like that, I wouldn't be misdirecting myself. That's the impression I'm given from the presentation of this information.
Chair, once again, I would indicate that it's from the payment database, so you would probably have to have the author of the document speak to the content of this. But we certainly have incurred expenditure for counsel that have been briefed through the OSA.
All right, thank you very much. So let me just ask some other issues. So I actually had this DJP Sutherland note, the one that's on the cover. This followed your meeting with him, and I'm supposed, I think you said you approached the Deputy Judge President and said, hey, man, we gotta solve this thing. He confirms your thing, that your statement earlier that they're so short of judges here to beg members of the bar to do it pro bono because they just don't have enough people, and he complains bitterly about the fact that the government is not financing its own criminal justice system. So he confirms what you said. Where I got a bit worried is paragraph 4. Can you see that on that same letter? Did you say it before? Can you read it out?
Chair, if I may start by just indicating this isn't the note that I was referring from.
Okay, but this is another one.
This is another one.
That's fine. Can you read 4?
Chair, paragraph 4 of the note from Judge Sutherland indicates that an aspect which in part though a minor one relative to the paucity of acting judges is the behavior of the RAF in DJ court. It is reported to me increasingly a practice has evolved in which an RAF representative turns up at the last minute, totally ignorant of the case and incapable of engaging even in settlement discussions, and thereupon files a belated notice of opposition. This provokes a postponement, albeit with punitive costs. One acting judge recently informed me that his entire role had been sabotaged by this ruse. I need not belabor the unethical nature of this conduct. It makes a mockery of the process of court.
Okay. Have you come across this sort of thing?
Chair, in terms of the court rules, there's a court rule, a High Court rule, Uniform Rule of Court 19.5. And in terms of that rule of court, the defendant is able to file a notice of intention to defend at any stage before judgment is granted. And that's, I think, in obviously the setting that Judge Sutherland is referring to the fact that notices of intention to defend are being filed, albeit at a late stage in the proceedings. But it's done in terms of a court rule, Chair.
There's a part that you've omitted there that is really critical, where he says, let me read it out. It has reported to me that increasingly a practice has evolved in which a road accident fund representative turns up at the last minute, totally ignorant of the case and incapable of engaging even in settlement discussions, and thereupon files a belated notice of opposition. Do you care to comment on that?
Chair, nothing further than obviously indicating that the process is in terms of Uniform Rule of Court 19.5. And if instructions are given to the State Attorney, albeit at a late stage, to attend to an action, that's certainly what they're doing in terms of the process.
Do you know what this reminds me of? It reminds me of Ms. Mtetwa's experience when she joined litigation. Do you remember when Ms. Mtetwa said, on the morning of the court date, somebody is looking for a mandate? 1. 2, somebody appears in basically they try to be in 2 courts at the same time, so they just haven't had time to prepare for the case in fairness to them, right? Wouldn't that point to that problem? Let's leave the uniform rules of court.
Certainly, Chair, in fairness to the State Attorneys, that's generally what would be happening.
So you understand Honorable Beasley's anxiety about the staffing, right? And the fact that there was no plan to deal with this here, because the judge and DJP Sutherland is not inexperienced. I think he is fairly advanced in years, and he calls this unethical. You understand? So this sort of thing, when this sort of thing happens, in your experience, wouldn't the judge be feel the need to award punitive costs?
Chair, the Uniform Rule of Court that I'm referring to provides for a provision of costs appropriately in terms of that practice. So the Uniform Rule of Court actually references a potential for a costs order along those lines.
Okay, so we have a situation here now where some matters are just totally undefended because you don't have enough people, by your own admission, right? Secondly, those who do turn up are forced to engage in this sort of thing through that situation Ms. Mtetwa was describing earlier on, right? And in the net result, the Road Accident Fund incurs punitive costs, which contributes to that higher cost of litigation per claim that Honorable Beasley was talking about. Do you see how the three link together?
I do, Chair.
And that's why this committee is sitting at night at this time. It's things like that. Right, so the absence, and you can extrapolate, I don't think this happens in the South Gauteng court, local division only. I think it happens throughout, because I might also ask the breakdown. Basically, one of the things we need to understand is what the caseload of each of the state attorneys is. Do you know what that is?
I do, Chair, and it varies from region to region. Obviously, the smaller regions have got caseloads of approximately 700 to 1,000, and in the larger regions, it can go upwards to 4,000.
Is it reasonable to expect a single attorney to handle so many matters at court?
Chair, it's not.
Right? So I think then we really can agree that, notwithstanding the costs of I think you might have noticed that here, members of the committee are generally fans of Ms. Mthethwa's job, so that you don't need to go to court. I think there is a unanimity in the committee that that's where you want to go. But the picture that I am seeing here is that the calculation of what actually the legal costs are, needs be carefully looked at. You can't really look at one column, which is how much was our paying attorneys, right? You also have to look at these things: punitive costs, inflated awards, and so on, from people that really shouldn't get the kind of monies that they get, because your people have up to 1,000 cases each. Did you say 1,000 or 4,000?
In some regions, it can go up to 4,000.
This is the point, right? So I think then, reasonably, at the point at which this decision was taken and you didn't take it, I don't think this couldn't have been foreseen. This is not rocket science here. Somebody at the Road Accident Fund knew what the caseload of the Road Accident Fund is, and had to have thought, I wonder what will happen when we cut the umbilical cord. What happens tomorrow? You understand? And they didn't. They didn't. It's not your problem. You have been roped in to solve the problem, right? So we appreciate you for that. In fact, I wanted to ask you, when you said you took the job, if you dislike yourself that much. I wanted to understand if you dislike yourself that much. But anyway, so that's the first part of my questions. Second part, let's deal with this rough one form thing. Who gives your state attorneys instructions on what defenses to put up on a matter? Are you made aware? How are those decisions made about what defenses are going to be put up in court?
Chair, the instruction generally comes from the operations space. Depending on what the nature of the instruction is, it could come from the claims environment, it could come from medical management. There's several ports of instruction coming into the state attorney.
Would you agree with your experience that, I had in my previous life a really good attorney who would say to me, if I have to choose between our case and their case, I would take their case. Which was a message to me that, Chief, leave it. They're going to beat us in court. You get me? So when you say operations, is there some kind of assessment of the appropriateness of the legal position that is going to be taken by the attorney? Because you could also engage in fruitless litigation where you can almost know what the outcome is going to be. Because there's case law, there's, so are you telling me that as the person who oversees these guys, you don't know what your guys are arguing tomorrow in court?
Chair, I think in terms of the nature of instructions, there's what we have known as the RAF stances, which is compiled by the Corporate Legal Services Department. which deals with the important stances that the organization has on certain issues such as foreigner claims, past hospital and medical expenses. So there's certainly guidance given when an instruction is given to the state attorney, and all of the state attorneys have been taken through strategy sessions on that document. And obviously when an instruction comes in from operations, and let's use the foreign claimant as an example, it will reference the RAF stance on foreign claims. So certainly, yes, Chair, I think there is awareness when an instruction is given on a stance matter as to what the nature of the defense is that the state attorney is expected to raise.
Okay, thank you. So let's take one of those common stances. I'll call them LPIIF1 and LPIIF2. LPIIF1 was the main litigation itself about RAF 1 form. I mean, there have been numerous others, right, where the road accident fund has been basically beaten out of court. But in LPIIF1, you know that the RAF 1 form was set aside, colloquially speaking, because there was there's board notice, there's RAF 1 form, etc., etc. So in effect, the minister doesn't turn up to defend his or her own decision. The minister says, I will abide. The road accident fund persists. And the court says you can't use this RAF 1 form, right? The road accident fund applies for leave to appeal. You remember that. You recall that judgment, because I'm going to go to it now. Right, so in the initial order, the court says, hey, we have a dilemma here. There are claims that were filed in terms of the old RAF 1 form. There are claims that have been rejected in terms of the new RAF 1 form. We can't just set this form aside. We have to determine what happens. You remember that part of the judgment. And basically they give the road accident fund until, I think, the end of September to contact everyone who had been rejected on the basis of the new RAF 1 form. You remember that? Okay. And let me just ask firstly, do you know if the road accident fund acted upon that order?
Chair, in terms of an operation environment, that would have to come from an operation space. I wouldn't be able to confirm whether that was complied with or not.
I do expect you to know in line of my next question, by the way, because it's really important. Because it affects the stances that your attorneys are going to take in future litigation, right? So the road accident fund either complies with that order in the meantime, or it doesn't. Surely somebody in your position should have an idea that on such an important, probably is the most important issue of litigation right now that the road accident fund has, right? So I'm just trying to understand what are the instructions to your state attorneys.
So, Chair, generally in keeping with the fact that the LPIIF matter has not been decided to conclusion yet, that's generally the instruction that comes in from the operation space.
Because, you know, on the application for leave to appeal in the High Court in Gauteng, the court is actually fairly disturbed by the fact that you know, I am so sorry, the way this document has been pulled together is not particularly helpful. So, okay, I'm about to find it. In fact, it's more towards the end. So it is the Republic of South Africa, that one at the back, Republic of South Africa in the High Court of South Africa, Gauteng Division. You see that? No, hang on. So that's a different one. I am so sorry. I want to go to a different judgment, so I will read it. I'm sorry. Basically, in granting leave to appeal, the court cites even other cases to say we are disturbed that notwithstanding, so we're granting you leave to appeal. But during the course of the proceedings, we were informed that you are not complying with our previous order to A, stop using this form, and secondly, to phone the people that had been rejected on the basis that their forms aren't compliant, their claims aren't compliant. So, am I correct to assume that to this day, because the Road Accident Fund is appealing, those people are still sitting outside, unregistered?
Chair, the LPIIF matter is being handled by the Corporate Legal Services Department, and I think it would probably be prudent for me to defer to the status of the matter with Corporate Legal Services, as well as what operations did in respect of the request in terms of the original order.
Mr. Phillips, what does your management of the state attorneys entail? I'm just trying to understand now, because you have a great experience, right? You were the RAF, you joined the bar, you've argued cases, and so on. I am worried that the Road Accident Fund, your own state attorneys, go and defy court orders, and you don't know about it.
Chair, as indicated, my role is an oversight role in terms of the relationship between the RAF and the Office of the Solicitor General, and I coordinate the process itself. I don't hold a delegation of authority to give instructions. I have a delegation of authority in respect of two pertinent aspects to the relationship with the OSA. But I don't give instructions. The instructions come from the operations space.
All right, it was actually a full bench judgment. I've found it. So anyway, so my concern, and I guess that's something we have to address. This is important because the stances that that Road Accident Fund lawyers take in defiance of the court order, I can bet you, attract punitive costs, because the Road Accident Fund loses each time. It loses each time. It would lose each time. You're a man of experience in the court. It would lose each time. There is an opinion that the Road Accident Fund sought from Advocate Ishmael Semenya, SC. Are you aware of it? You are aware that he says to the Road Accident Fund, stop doing this. It's in relation to a different matter, but the principle applicable is the same. You remember that. And the Road Accident Fund persists.
Chair, if I may, I think I made the point earlier during the course of the day. What I say to the state attorney grouping is give your informed opinion to your client, advise them of the risk attached to acting contrary to your opinion, as well as any potential adverse costs that could be incurred. And if your client still tells you to proceed, they accept the responsibility for that potential cost order that could eventuate. And that has remained what I have given to the State Attorney's Chair from the beginning.
Okay, so do you see how the legal costs keep creeping up, right?
I do, Chair.
They creep up in this way because the Road Accident Fund engages in really unnecessary litigation where there is a court order that says don't do this. They then go and seek independent opinion from counsel. I will read for the members what Advocate Ishmael Semenya says here. He sounds really frustrated by the fact that the Road Accident Fund is persisting. The RAF 1 form, he says, the RAF 1 form does not call for detailed information. It is not intended of itself to enable the fund to assess the quantum of the plaintiff's claim. It seeks to enable it to investigate the impact of the injury sustained. In order to do so, the RAF 1 form requires a disclosure of information to guide and facilitate the investigation. On the first page of the medical report section of the form, it seeks particulars of any emergency transport, etc., right? The third page, anyway, so he says, basically, that's all the RAF 1 form is there to do. We heard from not just from Ms. Mteto, from everybody, that the fundamental thing with RAF 1 form is that on a matter that has gone in the Busuku judgment to the Constitutional Court, where the Constitutional Court said, don't do this. Then the Road Accident Fund goes to a senior counsel. They ask for advice, and the senior counsel says, the Constitutional Court is the apex court. I don't know what you want me to do, but let me tell you the obvious anyway. Right? But you know, as you and I sit here, that the Road Accident Fund persists with something that has been ruled upon by the Constitutional Court. And I know that is not your responsibility, as you have explained, but this clearly is something that we must hold to Honorable Kubeka's point earlier on. Somebody must be making these decisions, right? Because it deals with these directives of the Road Accident Fund. So we're nearly done. But that's one of the things that we are concerned about. So one of the documents sent anonymously to us, it's the one that says Legal Services Court Monitoring Response, 20th September 2022. You've got it in front of you there. I've highlighted some parts. So anyway, what I like is that it does confirm some of what was being said, for instance, by Mr. Baloyi about lawyers withholding files and not wanting to hand them over and this kind of thing. But it also says some important things, and let's go together to 4.3. Okay, and this appears to basically cover both the panel period and the post-panel period, right? So basically, the background is what we were canvassing earlier, matters unattended and so on. And it explains. So number one, status of matters was unknown. Instructions not carried out by the panel, such as notice of intention to defend, pleas not drafted, reports not filed, and the RAF not being aware of this, causing default judgments and the files not being attended. This has been a major contributor to the historical and current default judgment challenges. Number two, matters being on the default roll due to the defenses being struck due to non-attendance of pre-trials and discovery affidavits. I suppose if I've got a caseload of 4,000 cases, I'll miss some. I mean, it goes without saying.
Chair, and I think that was one of the reasons why in the Johannesburg region, for instance, we instituted a separate team that dealt with trial interlocutory court work to deal with issues relating, for instance, to pretrial attendance and discovery affidavits, to try and streamline that process to ensure the gap was closed there.
Sure, but I mean, it still isn't, because we still don't have enough people. That's the bottom line, right? That's our earlier conversation. So this persists. So we will ask management to properly quantify the impact of all of this. But what is apparent to us is that some of the chaos that persisted with the panel of attorneys just got worse with you. Because if your view is that you need between 400 and 600 warm bodies, and you only have the number that you have, the Road Accident Fund will continue to pay to be unable to defend the claims, all the claims that it needs to defend, right? To ask for postponements and so on. And the problem is the person affected is a quadriplegic or paraplegic or whatever the case might be, right? So at the end of the day, we've got to think about the person behind all of this. The last thing I wanted to ask is, you said something earlier about the fact that the cases now have linked numbers. Was that something, you remember you said something about that by agreement the cases have to have linked numbers and so on?
Chair,
and the members know what a linked number is, by the way, believe it or not.
Chair, when I referenced the discussion, it was in regards that the request that I put to Judge Sutherland in Johannesburg, that all correspondence with the court had to contain a link number, if one was obviously in existence, so that when the court roll came in its form, the region was able to then populate the information to route it to the correct RAF department. When we receive court rolls with only a case number and the name of the plaintiff. There's no RAF information on that. And the request to Judge Sutherland was towards the end of 2023, so that when the team was populating the court roll, they were quicker able to establish if what the reference number of the RAF was.
Okay, so what happens if there is no link number?
Then it was a slightly more problematic issue. We had to then look at the identity number.
No, I mean, what do you do now? So if somebody does not include the link number, what do you do?
Well, if there's no link number, there may be an ML number, which is the pre-assessment claim process. And Chair, if it's a matter that's not registered, then we've got no claim on the system at all. But the provision is made for acknowledging the summons.
Okay, so there is no, in fact, there's no matter that goes unattended simply because it doesn't have either the ML or the link number. You do attend to them. It might be a bit of more of a hassle that it doesn't, but I'm assuming that you get back to that party and you say, please give us this information.
And Chair, I think I covered that in my presentation with regards to the summonses. There are the three sources. So it's the registered claims, the ML claims, and the NR claims. And obviously then the instruction would be given to the State Attorney grouping accordingly.
Okay, are you aware of any instruction not to action orders that did not have a signature on them, on account of the fact that courts were operating virtually and the judgments would be transmitted electronically by the orders would be transmitted electronically as a result of the COVID thing? Are you aware of any cases and litigation that arose as a result of that?
Jane, not to my knowledge, but I do recall there was an issue at one point around court, the stamp of the court not being on court orders. I'm casting my memory back to a point, possibly in 2022, where that may have been an issue when it came to payment on court orders.
Okay, that's fine. We will just have to get a bit more information. Let me just consult my notes. I'm nearly done. I think there are only 2 questions. Or 3 that I have, and then I will be done. Yes. So the number of registered claims has plummeted, as you know, because of the rough one form that we were discussing just now. And the matter will soon be argued before the SCA, right? Is that correct? Do you have a date for that? Okay, but it seems to be imminent, right? And the court may decide that the order of the High Court in Gauteng must be enforced, right? You know where I'm going with this, with regards to your caseload, right?
I do, Chair.
So you will go from 4,000 to 5,000, 6,000, 7,000.
Chair, I think the provisioning for the additional State Attorney resources, which I've suggested, already takes account of the NR and ML summonses. So I've already kind of provisioned for that in terms of the additional State Attorney requirement. The claims processing is something completely different.
Sure, but basically your caseload will accelerate because those things get back in vogue, and because Ms. Mtetwa and her colleagues no longer do what they were doing previously, your load gets bigger. Right.
Correct, Chair.
More legal costs, right? You see?
Correct, Chair.
Right. So at some point, we need to have this conversation with management about the real legal costs. I mean, you've shut down an avenue. We've got numbers here, and I shared them with the committee that you used to do 35,000 direct claims a year. It's down to just over 2,600. It's shifted those people onto you. Some of them are blocked by RAF 1 form from getting into the system, but not if, when the Supreme Court of Appeal, as you know, with someone of your experience, says in very strident language that the Road Accident Fund must stop doing this RAF 1 form. Your caseload is going to increase, and you're going to deal with matters of prescription there. You understand? Because in terms of the RAF's definition of the initial prescription, if somebody was in a hit and run in 2022, the 2 years is now expired and the RAF has not taken their claim. You understand? You see that, right? In terms of another, the 3 years has expired. Now the court says you've got to unwind the whole thing. So this is why we're having an inquiry, because it feels like, you know, these things don't matter, but I think you know they do. And the cost implication is enormous. So we will call executive management here and the previous boards to account for some of the stuff over here. But the picture that we draw from Ms. Mtetwa's account all the way to your experience with resourcing says there's no plan. There are legal stances that have been taken that occasion punitive costs. Your lack of capacity occasions punitive costs. It potentially occasions inflated claims because you guys can't be in every courtroom as you want to be. You understand? The last question I want to ask, you know, we asked the Road Accident Fund to favor us with some information, and part of that information is that they had to tell us about the people that they'd lost. You said task grade 16. Do you remember that when you were telling us about task grade 16? You remember task grade 16, and they told us that, yeah, that they lost about 32 people in the legal team at task grade 16. 32. Do you know what the job of the kind of work those people did in the legal team?
So, Chair, if I look at the list, there are some state attorneys obviously on the list.
Yeah.
And there are also, because the task grade of a state attorney is actually a management task grade.
Right.
So there would be, I note, manager litigation, manager regulation, manager legal advice. I note some of the state attorneys who resigned during the period since I was appointed. But generally, it's a senior management grade, task grade 16.
Okay, so you see the picture that's developing still, right? So the panel of attorneys is let go without a plan of how you replace them gradually so that you don't have this problem of not having people defend us from inflated claims, right? The people, it appears, that would be able to give legal advice, to manage litigation, the task grade 16, there is a, I counted on his task grade 16, 18, does it, do responsibilities get higher the higher the number is, or do they get lower there? So if you're 18, you are senior, right?
It's more responsibility, Chair.
Right. So these people are gone. Those people are gone, right? So it's your attorneys, it's your senior managers in legal. There's a list, they provided it to us, right? Those people are gone. You don't have enough people. It's a train wreck. Those are my words, not yours. But you see.
Chair, I'm certainly trying to fill my vacant positions as quickly as possible.
No, I appreciate your answer. It's not for you to use my language. I appreciate that. But this is how, Mr. Baloyi, you get to higher cost, legal cost per claim. Right? It's this stuff where you and Mr. Phillips here don't have capacity. The people that would support the operations team with making those assessments about whether to argue about a case in one way or another, they're also not there, they're gone. And we asked if they were replaced. And in some cases, yes, in some cases, no. In some cases, the attrition just continued to be high because people would come, stay for a month, 2 months, and then they would be gone. But that's why we are here. It's matters like that. Yeah, Mr. Phillips, let me thank you for assisting us. Mr. Baloy, you look like you want to say something.
Yeah, thank you, Chair. There was an issue that you raised around an appeal and what the process would be in terms of whether RAF should, in fact, during the course of appealing a matter or even applying for leave to appeal, whether the court order should be effected or implemented. In terms of Section 18(1), I think it is, of the Superior Court Act, a decision or a court order, once there's an application to appeal or an application for leave to appeal, is suspended pending that application or the appeal itself. The decision is taken. So I thought we should know that, Chair. Thank you.
I do. And so do the panel that presided over your application for leave to appeal. And they disagreed. Probably because they understand the practicalities of what I've just been discussing with Mr. Phillips here. Because whatever the position of the RAF is, the entity has a responsibility to make prudent decisions. So that if you are asked to unwind this thing, you're not faced with a problem. Let me ask this. How is a prescription interrupted, Mr. Baloy, from coming into effect?
Thanks, Chair. It's interrupted, obviously, by a summons.
Yes, that's my understanding too. So, in the case of the applicants who were rejected from being registered by the Road Accident Fund, you know what this means, right? The Road Accident Fund cannot issue summons against itself, can it?
No, Chair.
Okay, so what we're facing is that those people are going to need to challenge them, and basically they're going to come back, and they're going to come back with armies and armies of lawyers, right?
Yes, Chair. I assume they will.
That's my point. Honourable members, it's a bit late. I don't know if you have any further conversations you want to have. Okay. Ms. Mtetwa, Mr. Baloy, and Mr. Phillips, let me say this to all three of you. The one consistent thing that I've observed about people who work at the Road Accident Fund is their passion. Sometimes an employer just needs that. So despite the fact that we have tough discussions here, don't think we don't see your passion. Your passion for the victims of accidents, your passion for your work, your passion for the Road Accident Fund, and so on, right? We appreciate that. What we're all looking for is for all of this stuff to be over. And we can get to what Honorable Bila was saying earlier, that can we just make it simple for our people to file a claim and complete the process with the trauma of an accident and everything, and be done with it and get all the help they need as quickly as possible. I think most of us, and you've got to talk to your lawyer, feel like you're going to the dentist. It's like SARS, you know. SARS calling you. So I want to say I really appreciate that about the people that we've seen, even people that have left the organization or are going through a labor relations process and so on. The passion for the Road Accident Fund does come through, and that is an asset. And you guys and your colleagues, you need to protect that, because the last thing you need is people who are part of an organization and they couldn't care two hoots what's happening. So I want to appreciate all three of you. I want to appreciate you taking time, you sitting with us into the night here. I appreciate that very much. I hope you get good rest tonight. and you travel safely back home. Honorable members, you've also been champions, and I see that Honorable Maduna has stayed the course. It is still with us. So thank you, honorable members. We adjourn. Eh? Oh, sorry. It's my fault. I forget, because I'm also tired. So do you remember we discussed the issue of the letter that we sent to the former chief executive of the RAF? We need to have a discussion about that matter virtually tomorrow. It will not be a long discussion. It will be quick. Probably in the probably in the evening. Yeah, in the evening when you're all at home, and you can join on your phone and so on. Thank you once again.